Scapegoats or felons? Two Canton, Ohio police officers charged with the death of Frank Tyson. Well, this is something you may have never seen. On the screen we see Canton, Ohio uniformed police officers file into court to await a bond hearing outcome for two of their brothers in blue. Why would they be doing this when the two young officers were charged with reckless homicide of Frank Tyson? So, reckless homicide, in fact, is a third-degree felony charge which carries a maximum penalty of 3 years in prison and a fine of $10,000 and involves unaliving someone through reckless behavior. While we await the Stark County judge to arrive and watch the bond hearing, let me tell you what is going on, as there is discord between the president of the labor union for the Canton Police Department supervisors and the prosecuting attorney for Canton, Ohio, Stark County. In a nutshell, the president of the labor union for Canton Police Department supervisors issued a statement accusing politicians of exploiting these two officers as political tools and saying the timing of these charges being announced as uncoincidentally convenient as Election Day was 4 days away, the Stark County Prosecutor Stone is being challenged for his job. Basically, he is saying that the facts are being twisted and that true progress doesn't come from sound bites or half-truths. It comes from collaboration, investment, and open communications, not from using our officers as well-timed scapegoats to score political points. So I will leave you with that full article in the repository, and the attorney for Tyson's family in a press conference said, "We know who the bad guy is. It wasn't Frank. The indictment tells us who we need to focus on." And at the same conference, the Stark County Prosecutor also spoke. So let's listen to part of that.
Good afternoon. Was no different. Dennis Barr, my chief of the criminal division, and I reviewed this case in its entirety, and we presented it to the grand jury earlier this week. As the normal process, we presented the case to the grand jury in the same fashion with witnesses and evidence, and once we were done presenting, we exit the room. After the grand jury deliberated, they voted to indict Officers Burch and Schoenegge with reckless homicide, a felony in the third degree in the death of Mr. Frank Eugene Tyson. Reckless homicide, as stated, is a third-degree felony with a potential of 36 months imprisonment and up to a $10,000 fine. I want to stress that these officers are innocent until proven guilty. As I prepare to answer questions to the press, I want to remind you I cannot share the details of grand jury testimony, and because this is a pending case, my ability to respond and provide information regarding the case is going to be limited.
Okay, so there's the heightened differences of opinion, and we are going to try and answer the question, are the officers being used as scapegoats, or is there a valid charge as to what occurred? Okay, so he didn't really give us very much information other than, they brought the facts to the grand jury and these officers were indicted. But what I can tell you is the police body cam footage was released, and we're going to take a little look at that, but I'll leave you the full clip so you can look at it for yourself. And we also found out a little bit of background from some news media, and we get some statistics, and we will have some commentary from some rather famous YouTubers who have well over 1 million subscribers. Then you decide, are these Canton police officers scapegoats or felons? Should the judge give them bond, or should they remain in jail before their trial? Let's talk about what occurred. Police released body cam footage. At 20:23, they are driving to the scene. They arrive 1 minute later. Tyson had driven his car into a utility pole, knocking it down. When the officers arrived, they were told that Tyson had run off.
guy who did this, he's in the VFW. He ran in there.
He ran in where?
Right now, yeah, and there's cars right there.
All right.
Yeah, he's in the VFW right now. Right in the VFW.
The officers walked to the location where they saw Tyson's car, and they found it, a few minutes later, and then they were told by residents that Tyson was in the bar. Less than 2 minutes later, the police entered the bar. So let's have a little watch of that, and then I'll come back to you.
Where's your word? You called 911.
That's that gentleman standing at the door right there.
Please get him out of here now.
I ain't even there. No, we're going outside. We're going outside.
No, you ain't killing me. You ain't killing me tonight. You ain't killing me. No, you guys are killing me. They're on it. They're trying to kill me. 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 Why are you trying to kill me? They're trying to kill me. They're trying to kill me. Tell me the sheriff department. Call the sheriff department. Call the sheriff department. They're trying to kill me. They're trying to kill me. They're trying to kill me. Call the sheriff. Call the sheriff. Call the sheriff first. Call the sheriff. 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 You're gonna kill me. Call the sheriff.
You're on the fucking ground.
Call the sheriff. 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 They're gonna kill me. They're gonna kill me. They're gonna kill me.
You're gonna get sprayed.
I don't get close, sheriff.
You're gonna get sprayed. Don't spray him.
Call the sheriff.
Don't spray him.
Call the sheriff. They're gonna kill me. Call the sheriff. Call the sheriff.
I got him. Here it goes. Got him.
So what we just saw there was less than 2 seconds after the police walk in the building. They approach Tyson. He acts erratic, yelling at them. They're going to kill him. He says to call the sheriff. In my view, given he's just knocked down a utility pole, he could be in shock, and I would expect the officers had called the EMTs, because he's clearly having some sort of an episode, and we find out why later, what that could be. So I will just do some still shots now and give you my take on what's happening. Then you can go check out the full body cam yourself in the description area below. Tyson struggles with the officers for about 1.5 minutes. He is handcuffed, and again, I would have expected officers to approach him in a more calming way, considering he had just been in an accident, and they could have de-escalated the situation instead of handcuffing him straight away. Tyson is saying, "Get off me," as soon as they handcuff him, while another officer puts his knee on his back. So they yell at him to calm down. He says, "I cannot breathe." Now, I, again, would expect officers to turn him over and sit him up. Remember, they know from eyewitnesses that he was the one in the accident. Tyson was telling officers he couldn't breathe. I counted around 7 times. The officers say to him, "You're fine." We can hear in the body cam video that Tyson is breathing faster and heavier. Another minute goes by. I no longer hear Tyson's heavy breathing. Officers are busy gathering information from those in the bar, and one officer proceeds to cross Tyson's legs behind him. 35 seconds later, Tyson is shaking his feet, and the officer tells him to stop fighting. A few seconds later, another officer decides to check his pulse. The officer that checked the pulse says nothing after he checks and just walks away. Now, my research found that there are risks of being in the prone position, and they can start within 1 minute of someone being face down. So the officer that had walked away, another officer says to Tyson, "Stand up," and attempts to turn him over with no luck. The other officer realizes something is wrong and says, "Oh, F," and he starts to shake Tyson. They again try to get him up. They turn him over at around 20.3609. He is now on his side. So he was in the prone position for about 7 minutes, I believe. And they uncuff him a minute later. They cannot feel a pulse and tell the medics to step it up. Here, let's listen to what the risks are of being in the prone position.
Body cam video shows officers holding Tyson's face down, also known as prone. Now, this morning, our sister station in Minneapolis explains the controversial tactic used in Ohio and its similarities to other cases across the country. Now, we do want to warn you, over the next few minutes, we will be showing you video of several police encounters, and some of what you're about to see may be disturbing.
Okay.
I can't breathe.
You're fine.
Yep.
We now know Frank Tyson wasn't fine. We also know he's not alone. He's one of more than 130 people our investigation identified who, since 2010, died in police custody while held face down in the prone position.
Get off him. Get him on his side. Get him upright.
We'll return to that news in just a minute, but what happens next is they start CPR. The ambulance, they seem to be taking a long time, so the police give him 2 doses of Narcan. They take turns giving him CPR. They're very worried. They're saying, come on, stay with us, stuff like that. Sadly, by the time the EMTs get there, Tyson dies. He was 53 years old. The preliminary autopsy report ruled manner of death was homicide, and the cause and manner was a combination of acute intoxication by cocaine and alcohol, obesity, cardiovascular disease, and cardiopulmonary arrest, meaning that his breathing and blood circulation stopped in association with a physical altercation and prone restraint, which means he was in the face down position. So let's listen to the rest of that news.
These deaths are labeled as a homicide. Prosecution rarely charges officers. Now, of all the cases in the investigation, AP identified just 28 deaths that led to homicide charges. However, some experts say law enforcement shouldn't bear all the blame, pointing to a rise in the mental health crisis as well as the increase of drugs like cocaine or methamphetamine.
We look at law enforcement and think, well, why can't you just take the guy in? Well, a lot of times it's not dependent on the officer. It's dependent on whether the guy will go along with it. And sometimes they're out of their mind-body disconnect. They don't know what they're doing. So I think we just have to slow things down. It's called the pacing of the event.
After hearing that, can you now understand the visual support by the Canton, Ohio police officers who showed up to court for the officers charged and who have been sitting in jail since the incident? Let's hear what the prosecutor had to say about this visual support in court at the bond hearing.
In my years as a prosecutor and in my years in the courts, I've never seen what I'm seeing today. And we would ask that the presence of over 50 law enforcement officers gathered here today not influence in any way that decision. In my years as a prosecutor, and in my years in the courts, I've never seen what I'm seeing today. And it's concerning that the concept of presence is being used in this way as taxpayers are paying for these officers to be here. While we support their right to do what they're doing to support their officers, we just implore the court to use the same fairness that it would use in every other case. Thank you.
So we heard the prosecutor was upset with the uniform officers in court. I thought, is this legal to be in uniform while not on duty? Turns out this is only allowed with written permission. So are we to assume they had written permission? I can understand officers wanting to show support, just as I feel the loss the Tyson family had to deal with.
We just implore the court to use the same fairness that it would use in every other case. Thank you.
Mr. O'Byrne, on behalf of Mr. Burch.
Thanks, Your Honor. On behalf of Camden, Your Honor, we'd ask the court to set the bond at the felony 3 level. My understanding in reading the code is it's not an offense of violence, so we'd ask the court to consider that. Mr. Graham, Attorney Graham and I have discussed that. It's an expungable offense.
Let me just pause this for a second, as I think you'll find this interesting. An expunged offense in Ohio is a criminal conviction that has been cleared from a person's record and sealed from public view. It can make it look like it never happened, and there are some benefits. So with an expunged record, you can rent a house, obtain professional licensing, you can get a job, and when your employer says, have you ever been convicted? You can say no, so you can deny it. So those are some of the benefits. Okay, let's continue.
Attorney Graham and I have discussed that. It's an expungable offense. And being in front of this court for a number of years, we know the court will be fair, but we would ask the court for that bond that was agreed upon. Thanks, Your Honor.
Mr. Graham, on behalf of Mr. Schoenegge.
Your Honor, we would likewise just ask that a bond be set in accordance with the schedule. I believe that is $25,000, 10%. And we really have nothing further to add at this time.
The judge goes through her decision-making process before deciding bond. Let's hear that clip.
Article 1, Section 9 of the Ohio Constitution provides that where a person is charged with any offense for which the person may be incarcerated, the court may determine at any time the type, amount, and conditions of bail. When determining the amount of bail, the court shall consider public safety, including the seriousness of the offense and the person's criminal record, the likelihood a person will return to court, and any other factor that the General Assembly may prescribe. Revised Code Section 2937.011 of the Ohio Revised Code provides that any financial conditions of release shall be related to public safety, the defendant's risk of non-appearance in court, the seriousness of the offense, and the previous criminal record of the defendant.
Let's pause it right there, as a media outlet has published the police officers' employment records, which will help us to understand what the judge is considering, and then we'll go back to the court case to hear her decision.
Also this afternoon, 3 News obtained the personnel files for the officers involved. Matt Rascone has been combing through them and joins us with details from the newsroom. Matt, what did you find today?
Hired around the same time at the end of 2022 before they started the police academy. And most of what's in the personnel file is the hiring process and just a bit of what we know about their short career leading up to the encounter with Tyson.
Both police officers who responded the night of April 18th had only been serving on the streets of Canton for a matter of months. They graduated from the Basic Training Academy at Stark State College in July last year. During the hiring process for Officer Camden Burch, the investigator recommended him for the job, but he also expressed concern that Burch was fired from Target for stealing. While he does show many positive traits which would excel in law enforcement, I fear that taking responsibility for his actions is a problem for him. Last year, Burch was reprimanded for failing to report for duty for 2 different shifts. In the recommendation for Officer Beau, the investigator described him as a very good candidate, well-mannered, well-liked, and respected among his peers. While pursuing a suspect in September, he reversed his car and accidentally hit a concrete barrier. Schoenegge has received 2 commendation awards since he was hired, one for his swift response and persistence in apprehending an armed suspect, and another for his teamwork and relentless pursuit of suspects.
And both officers received good recommendations for the job from neighbors and others they know.
Okay, so that helps us out a lot. Now let's get back to the bond hearing and hear what the judge has decided.
Of the Ohio Revised Code provides that any financial conditions of release shall be related to public safety, the defendant's risk of non-appearance in court, the seriousness of the offense, and the previous criminal record of the defendant. In consideration of the aforementioned, the court finds that the established bond, traditional for Stark County, of $25,000 to be in accordance with those factors, the court sets the bond in each case at $25,000, 10% for cash surety. Further, should the defendants post the established bond in this case, each shall be subject to pretrial release supervision. Mr. Stone, anything further on behalf of the state of Ohio?
No, Your Honor, not at this time.
Mr. O'Byrne?
No, ma'am.
Mr. Graham?
No, thank you.
The next scheduled matter in this case is arraignment set for November 8th, 2024 at 8:30 a.m. A pretrial will thereafter be scheduled. Anything further?
Thanks, Your Honor. Appreciate it.
Thank you.
And counsel, if you could just approach, please.
So, what do you think? Was the judge's decision fair? Now, I haven't noticed a trial start date at the time of recording this video, but I think it would be a good hearing to watch. What do you think? And remember when I said Frank Tyson could be heard several times saying he couldn't breathe? As you can imagine, the community brought up the lessons learned from the George Floyd trial, which, as it turns out, that case is being challenged. And my research also found some great commentary on this by the Hodge twins, who I just love, as their videos are well thought out and they have an amazing background. So let's have a watch. I'm only going to play a few clips, and I think it really does speak to what's happening over in the case in Canton, Ohio, that we've been talking about in this video. So it will help us decide if these officers are scapegoats or felons.
Derek Chauvin's defense team may examine George Floyd's autopsy, heart tissue, and fluids. The defense asked for the court order as part of Chauvin's appeal, which seeks to test a new theory in Floyd's death. In 2021, a jury convicted Chauvin of murdering Floyd. Chauvin's new defense team argues that a heart condition, not Chauvin's knee on Floyd's neck, caused Floyd's death, and they're hoping the examinations can prove their case. The examination could be used as evidence in Chauvin's appeal, as Chauvin argues his lawyer, Eric Nelson, provided ineffective counsel during trial.
I used to arrest shoplifters, and I remember in my training catching shoplifters. They told us, elderly people, people overweight, do not, if they ever on their chest and you're trying to handcuff them after you arrest them, and you're putting a lot of weight, you got to understand you should get that task completed in seconds, because you can actually suffocate somebody by just laying them, a healthy person, just lay them on their stomach, and then you push your body weight on them, and you can actually suffocate them. Well, it's like not elderly and fat people. Yeah, it's not suffocate. You can make their heart stop beating. They go into cardiac arrest. All of that. And I was taught that as a loss prevention agent, arresting shoplifters after they leave the store and they shoplifted. They said no matter how healthy they are, when you're arresting somebody, handcuff them, don't have them on that chest too long. Yeah. But that tactic he was using, putting his knee on his back, that was to keep him from moving or running, which he already had him handcuffed. I don't know why he just didn't roll him on his side. That's the way he was trained. I don't care what my training has told me, but maybe I'm talking like a Monday morning quarterback after all the information that's came in. But if somebody can't breathe, you don't lay them on their chest. Right. That compromise, it doesn't stop them from breathing, but it doesn't help either. Yeah, and it looks bad. Yeah, to a novel person. Yeah, and it's harder to breathe. If you're having trouble breathing, you sit the person up. You don't lay them on his chest and put your knee on the shoulder, or roll them to the side. That's the only thing I can nitpick and say. All your body weight is on the ground, pressing down on your lungs, so it's harder to breathe. And to his defense, his police academy taught him to do that. Yeah, it's in their handbook too, right? Yeah, they was taught to do that. Well, and we all know police officers, when it comes to their interaction with the public, they're like robots. They do the same thing. They're very repetitive. They do the same thing over and over. They never actually really think for themselves, and they use that against them during this trial.
So remember, I've only played a few clips from their full videos, so be sure to check them out. And I'm kind of getting the feeling that it's a bit of both. They're a bit of scapegoats, and they should have known better. And is it about their training? Well, we'll have to hear what happens in the trial. I'm willing to listen to the evidence prior to making my views and my opinions known, but I certainly think if we can pass this message on to law enforcement of the dangers of the prone position, then at least we accomplished something. So yeah, be sure to share and like this video and let me know your thoughts. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.